A federal judge is blocking the Trump administration from requiring that voters prove their citizenship. President Trump had requested that federal voter registration forms require documentary proof of citizenship, like a passport. But District Judge Colleen Collar-Catelli found that to be a violation of the separation of powers, writing that, quote, the president lacks the authority to direct such changes.
The judge has ordered President Trump's administration to stop firing federal workers during the government shutdown. This temporary restraining order comes as White House Budget Director Russell Vought and court papers filed in that matter already affirmed that roughly 4,000 federal workers have received layoff notice. They're called reduction in force notice, RIFs, and more are expected.
A federal judge today ordered that the Trump administration temporarily end its deployment of the National Guard in Los Angeles and return control of the Guard to the state of California. In a lengthy written order, District Judge Charles Breyer decided there was no evidence that federal law was being obstructed in Los Angeles.
A federal judge ordered an end to the months-long National Guard deployment in Washington, D.C. to tackle crime, declaring that the use of troops was unlawful. It's the latest legal resistance against President Trump's troop deployments in American cities as a means to suppress protests, combat crime, or safeguard federal buildings and personnel, including ICE agents. It comes just days after a Tennessee state judge issued a temporary block on the mobilization of Guard forces in Memphis, which was activated by the Tennessee governor at Trump's behest.
There's a moment in every authoritarian playbook when institutions stop playing nice. When they realize that deference gets interpreted as permission, that restraint enables abuse, that polite requests for compliance just give bad actors time to do more damage. The federal judiciary just hit that moment. In December 2025 alone, federal judges issued 4 major injunctions blocking Trump immigration policies, rejected an administration emergency appeal at the Supreme Court, and escalated their language from cautious concern to explicit contempt findings. Judge Paula Zinnis in Maryland didn't just order a man released from unlawful detention. When the government tried an end run by having an immigration judge create a removal order the same night, she granted an emergency restraining order at 7:30 the next morning and wrote that the government had detained him without lawful authority. Twice, Judge Casey Pitts in Northern California issued a 67-page injunction finding the administration's re-detention policy arbitrary and capricious, with no contemporaneous rationale. Judge Beryl Howell in D.C. ordered the government to document every single warrantless arrest going forward, creating a paper trail for future constitutional challenges. And here's the number that matters most. 225 federal judges have ruled against Trump's mandatory detention policy in over 700 cases. Only 8 judges sided with the administration, 6 of them Trump appointees. That's not judicial activism. That's a 96% rejection rate across 35 states by judges appointed by presidents from both parties, including 23 Trump appointees ruling against him. The judicial consensus is clear. Trump's immigration detention policies violate the Constitution, federal statutes, and the Administrative Procedure Act. And judges are done giving him chances to comply. They're issuing emergency orders within hours instead of weeks. They're certifying nationwide classes affecting tens of thousands of people. They're finding contempt when orders are defied. They're explicitly documenting government lawlessness in written opinions for the permanent record. And on December 20th, even the conservative Supreme Court said no, rejecting a Trump administration emergency appeal for the first time in 11 months. This is the federal judiciary finally treating the Trump administration like what it is, a repeat offender that ignores court orders, lies to judges, and governs through lawlessness. Let's decode what changed, why it happened now, and what it means for the broader fight against authoritarianism. Let me give you the scale of what we're talking about. As of late November 2025, 225 plus federal judges had ruled against Trump's mandatory detention policy across more than 700 cases. Only 8 judges sided with the administration. 6 of them were Trump appointees. That's judges from 35 plus states, appointed by Reagan, Bush Sr., Clinton, Bush Jr., Obama, Trump, and Biden. And 23 Trump appointees, people he personally selected for the bench, ruled against his policy. This isn't a partisan split. This isn't conservative judges versus liberal judges. This is a near unanimous judicial rejection of policies that are so clearly unlawful that even the judges who owe their seats to Trump can't defend them. The mandatory detention policy, which we covered in detail in previous videos, reinterprets a 30-year-old statute to classify virtually all undocumented immigrants as subject to indefinite detention without bond hearings. The administration did this through an internal memo. No notice and comment rulemaking, no public process, just a policy change that stripped tens of thousands of people of due process rights. And judges across the country looked at that and said, no, that's not what the statute says. That's not how the Administrative Procedure Act works. That violates due process. Not in close calls, not in split decisions, in overwhelming consensus. Legal analyst Steve Vladeck, who tracks these cases closely, noted that judges were writing thorough, persuasive opinions, finding that the policy defied common sense reading of law. This isn't judicial activism. This is the judiciary doing its job, reviewing whether executive actions comply with the Constitution and federal statutes. And the answer from 225 plus judges is no. But it's not just the number of rulings, it's how the language has evolved. In early 2025, judicial opinions were cautious. Judges wrote that policies were concerning or raised questions. They suggested the government should reconsider. They issued preliminary injunctions with narrow scope, giving the administration the benefit of the doubt. By mid-2025, the language firmed up. Judges started writing that policies likely violate due process and defied common sense reading of law. They began certifying nationwide classes and ordering mandatory bond hearings. But December 2025, the gloves came off. Judge Zinnes in Maryland wrote that the government detained Kilmar Abrego Garcia without lawful authority, and she used that phrase twice for the same person. She documented that the government misleadingly claimed Costa Rica wouldn't accept him, when Costa Rica publicly stated their offer was firm, unwavering, unconditional. Judge Pitts in Northern California wrote that the redetention policy was arbitrary and capricious, and that DHS provided no written explanation for the practice. She concluded, the natural conclusion is that no contemporaneous rationale existed. Translation, they just started grabbing people. No reason, no process, no justification. Just arbitrary detention. Judge Sunshine Sykes in California's Central District found that the government specifically directed immigration judges to ignore federal court orders, not accidentally, not through miscommunication. The administration explicitly told immigration judges who are DOJ employees to defy federal district court rulings. Even the Fourth Circuit Court of Appeals, reviewing the administration's gutting of oversight boards, wrote that Trump's actions call into question whether the administrative process works as Congress intended. Sealins. That's appellate court language for, you broke the system so badly, we can't trust it anymore. This isn't cautious skepticism. This is documented contempt. Judges are no longer assuming good faith. They're treating the administration as a repeat offender that systematically defies orders and lies to courts. And they're writing it down, creating a permanent record, building evidence for contempt proceedings and future accountability. It's not just what judges are saying, it's how fast they're saying it. During Trump's first term, courts took weeks to issue temporary restraining orders on things like the travel ban and the Muslim ban. The administration had time to implement policies, cause harm, and then litigate. Now, emergency orders are being issued within hours. The Abrego Garcia case is the perfect example. Judge Sinis ordered his release on December 11th. That night, the same night, an immigration judge issued a decision claiming the 2019 protective order erroneously omitted a removal order, a transparent attempt to create legal justification for redetention after a federal judge ordered release. Abrego Garcia's attorneys filed an emergency motion at midnight. At 7:30 the next morning, December 12th, Judge Sinis granted the emergency restraining order blocking redetention. 7.5 hours from midnight filing to court order. That's not judicial caution. That's a judge who knows the administration will cause irreparable harm if given any time to act. So she's moving at emergency speed to prevent it. And it's not just Judge Sinis. Judge Sykes in California issued clarifying orders within days when the government tried to ignore her November class certification ruling. Judge Pitts issued a fully reasoned 67-page preliminary injunction as an emergency order, not a brief temporary restraining order, but a detailed legal opinion explaining exactly why the policy is unlawful. Courts are learning. They studied Trump 1.0. They know that narrow orders get appealed, diluted, and bypassed. That slow responses mean harm is already done before relief arrives. So they're moving faster, issuing broader orders, using stronger remedies, because they've learned that against deliberate defiance, only escalation works. It's not just speed, it's the tools judges are using. In early 2025, courts were issuing individual habeas corpus petitions, case-by-case releases for specific detainees. By mid-2025, they moved to class certifications. Judge Sykes certified a nationwide class of tens of thousands of people affected by the mandatory detention policy. That's not one person walking free. That's a systemic remedy affecting an entire population. By December 2025, judges are using their full constitutional arsenal. Final judgments with declaratory relief. Judge Sykes didn't just issue a preliminary injunction. She issued a final judgment declaring the policy unlawful. That carries more weight. It's harder to appeal. It's a permanent ruling, not a temporary one. Contempt findings. Judge Zenas didn't just note that the government violated her order. She documented repeated violations, detention without lawful authority happening twice for the same person. That's laying groundwork for contempt proceedings, for sanctions, for consequences. Discovery obligations. Judge Howell in D.C. ordered DHS to document the factual basis for every warrantless arrest going forward. That creates a paper trail. It makes agents think twice before conducting questionable stops. And it generates evidence for future constitutional challenges. Statewide and nationwide scope, Judge Pitts paused all courthouse arrests across Northern California and the Pacific Islands. Judge Sykes certified a nationwide class. These aren't narrow individual remedies. They're broad injunctions that affect policy implementation system-wide. Explicit defiance findings. Judges are no longer implying that the government might not be complying. They're stating explicitly in written opinions that become part of the permanent record that the administration is defying orders, lying to courts, and acting without legal authority. These are the tools judges always had. They're just finally using them. And then there's December 20th. The Supreme Court rejected the Trump administration's emergency request to halt the immigration judge's free speech lawsuit. That might not sound dramatic, but here's the context. Since January 20th, 2025, the Trump administration has filed 32 emergency applications with the Supreme Court. They won about 24 of them. That's a 96% success rate on the emergency docket, also called the shadow docket. because it happens without full briefing or oral arguments. December 20th was their first loss in 11 months. And there were no noted dissents, meaning even the conservative justices, even Justices Thomas and Alito, didn't publicly object to denying the stay. The case involves immigration judges challenging DOJ policies that require them to get prior approval for any public speeches about their work. The National Association of Immigration Judges sued, claiming First Amendment violations. The administration wanted the case sent to the Merit Systems Protection Board instead of federal court. But here's the problem. Trump gutted the MSPB. He fired the special counsel. He removed board members. He left it without a quorum. So the administration's argument was essentially, don't let a federal court hear this case. Send it to an agency we deliberately destroyed so it can't function. And even the conservative Supreme Court said, no, that's too much. The court wrote, at this stage, the government has not demonstrated that it will suffer irreparable harm without a stay. Translation, you're not going to die if a district court reviews your gag order. Stop abusing the emergency docket. This is significant because it shows that even the court that gave Trump near total victory on the emergency docket for 11 months has limits. They won't let him destroy oversight agencies to avoid judicial review. They won't rubber stamp every emergency request just because it comes from the executive branch. And that creates an opening. If they said no once, they might say no again. On other issues, in other contexts, the wall isn't impenetrable anymore. So why now? Why are judges escalating in December 2025 after 11 months of relatively cautious rulings? Because the pattern became undeniable. Abrego Garcia was deported in defiance of a 2019 court order, then redetained twice after federal judges ordered his release. That's not bureaucratic error. That's systematic defiance. The government lied to Judge Zinnes about Costa Rica. They said Costa Rica wouldn't accept Abrego Garcia. Costa Rica publicly contradicted them, said their offer was firm and unconditional. The government got caught in a lie to a federal judge in a written opinion. Judge Sykes found that the administration explicitly ordered immigration judges to ignore federal court rulings, not through confusion, not through miscommunication, through direct orders from DOJ to immigration judges, defy district court rulings. 700 plus cases created an undeniable statistical pattern. When one judge rules against you, you can call it an outlier. When 225 judges rule against you across 35 states, including 23 judges you personally appointed, you can't dismiss it as activism. That's consensus. 23 deaths in ICE detention in 2025 alone. For context, there were 24 deaths in the previous 4 years combined. People are dying, and the human cost of judicial restraint, of giving the administration time to comply, of issuing narrow orders that get appealed and delayed, is measured in lives lost. Judges are realizing that restraint enables harm. That deference gets interpreted as permission, that the only way to enforce constitutional limits against deliberate defiance is escalation. So they're escalating. Faster orders, stronger remedies, explicit findings of lawlessness, contempt proceedings, discovery obligations, nationwide injunctions. They're using the full power they always had because they've learned that nothing else works. Here's the structural reason this is working. Federal judges have lifetime appointments under Article 3 of the Constitution. They can't be fired for ruling against the president. Their salaries are constitutionally protected, can't be reduced as retaliation. This is the design the founders created. They understood that executives would overreach, that majorities would trample rights, that someone needed to be insulated from political pressure to enforce constitutional limits. So, they created an independent judiciary with lifetime tenure, with salary protection, with the power to review executive actions and declare them unlawful. And it only works if judges use that power. If they defer reflexively to executive authority because they're worried about being called activists, if they issue narrow orders that can be easily bypassed, if they avoid imposing consequences when their orders are defied, then judicial independence is meaningless. But these judges, Zinnis, Howell, Sykes, Pitts, and 221 others, are using their full authority. They're not worried about being attacked. They know they'll be called Obama judges or activist judges. Or accused of overstepping authority, they're doing it anyway because they have lifetime appointments and constitutional authority, and they understand that if they don't use it now, if they let the administration ignore orders, lie to courts, and govern through lawlessness, then judicial power means nothing. That's the test of judicial independence. Not whether judges have formal protections, whether they actually use the power those protections give them. And right now, they are. Let's talk about how the administration and its defenders are responding. One judge shouldn't override the president. Judge Cummings, in a Seventh Circuit case, asked, how could it be that one district court judge in the United States can entrench policy positions from one administration to the next? But it's not one judge. It's 225 judges from 35 states, appointed by multiple presidents, including 23 Trump appointees. And the answer to Judge Cummings' question is because that's how judicial review works. If a policy is unconstitutional or violates federal statutes, it doesn't matter how many administrations want to implement it. It's still unlawful. Unelected judges rewriting law. Solicitor General Sauer, in a brief to the Supreme Court, argued that unelected judges do not get to update the intent of unchanged statutes. But judges aren't updating anything. They're enforcing statutes as they've been interpreted for 30 years. The Trump administration is the one rewriting the law through internal memos without notice and comment rulemaking, in violation of the Administrative Procedure Act. And unelected is the point. That's why judges have lifetime appointments, so they can enforce constitutional limits without worrying about electoral consequences. Checks and balances require that someone unelected can constrain elected officials. Otherwise, there are no checks. Just majoritarian power without limits. Administrative remedies must be exhausted first. The administration argues that immigration judges should use the Merit Systems Protection Board instead of going to federal court. That federal employees must go through administrative processes before seeking judicial review. But Trump gutted the MSPB. He fired the special counsel. He removed board members. He left it without a quorum. As the Fourth Circuit noted, Trump's actions call into question whether the administrative scheme works as Congress intended. You can't destroy the administrative process and then demand people use it. That's like breaking someone's phone and then complaining they won't call you. These detainees are dangerous criminals. DHS claims that 70% of ICE arrests involve people with criminal records. They use that to imply everyone detained is a violent threat. That judges are releasing murderers, but criminal record includes civil immigration violations, decades-old minor offenses, traffic tickets. Many detained people have no criminal record at all, like the Iowa father who missed his daughter's cancer treatment while detained. And bond hearings don't automatically release people. They assess whether someone is a flight risk or danger to the community. That's due process. That's how the system is supposed to work. The administration wants to skip the hearing entirely, detain everyone indefinitely, regardless of individual circumstances. That's not law enforcement. That's arbitrary detention. Let me be very clear about something. These cases are about immigration detention, but the principles at stake apply to everyone. Is the government can detain immigrants indefinitely without hearings. It can do the same to citizens. If courts defer to executive authority on immigration because of plenary power, That precedent spreads to other areas. If the administration can ignore court orders without consequence, judicial review becomes meaningless for everyone. Habeas corpus, the protection against arbitrary detention, doesn't just protect immigrants. It protects all of us. It's been a fundamental right since the Magna Carta. It's in the Constitution. And if it erodes for one population, it erodes for everyone. Due process, the requirement that government follow established procedures before depriving someone of liberty, applies to everyone in the United States, regardless of citizenship status. The Fourth Amendment, protection against unreasonable searches and seizures, doesn't have a citizenship requirement. It protects everyone from warrantless arrests based on race, ethnicity, or appearance. When judges enforce these principles in immigration cases, they're preserving the constitutional infrastructure that protects all of us. Because the next time the government wants to detain someone without a hearing, the next time they want to ignore court orders, the next time they want to conduct warrantless arrests based on suspicion, they'll point to immigration as precedent, unless courts draw the line now. And that's what these 225 judges are doing, drawing the line, saying the Constitution applies. Court orders are binding. Due process is mandatory, not just for immigrants, for everyone. Here's what gives me hope. Institutions are learning. The federal judiciary studied Trump 1.0. They saw how the administration exploited judicial restraint, delayed compliance, bypassed narrow orders, and ignored rulings when they thought they could get away with it. And now they're responding differently. Faster emergency orders, broader injunctions, stronger remedies, explicit findings of defiance, contempt proceedings. This is adaptation. This is institutions recognizing that old norms don't work against deliberate lawlessness, that restraint enables abuse, that escalation is required to match defiance. And it's not just judges. It's Democratic state attorneys general coordinating lawsuits. It's civil rights organizations sharing litigation strategies. It's advocacy groups documenting abuses and filing coordinated challenges. It's a network of institutional resistance that's getting more sophisticated, more coordinated, and more willing to use the full extent of its power. That doesn't mean we're winning every battle. The administration still has enormous power. They still control enforcement. They still have the Supreme Court on many issues. But the idea that institutions are helpless, that courts can't constrain executive overreach, that authoritarianism is inevitable once someone wins an election, that's being proven wrong in real time. 225 judges just demonstrated that institutions can resist when they choose to. That judicial independence works when judges use it. That constitutional limits have teeth when courts enforce them. The administration will appeal. They'll ask for stays. They'll attack judges as activists. They'll try to forum shop for more favorable courts. And some of these orders will be overturned. Some injunctions will be narrowed. Some cases will reach the conservative Supreme Court, which might rule against the challengers. But the pattern is established. The consensus is clear. And the judicial record is being built. Every written opinion documenting government defiance is evidence for future accountability. Every contempt finding is precedent for enforcement. Every nationwide class certification is a model for other cases. And every person who walks free because a judge ordered their release, every family that stays together because a bond hearing found no flight risk, every immigrant who gets representation because courthouse arrests are blocked, that's a victory. That's harm prevented. That's a life not destroyed. This is how institutions resist authoritarianism. Not through one dramatic confrontation, not through a single case that solves everything, but through grinding, sustained use of constitutional authority, through judges who refuse to defer, through orders that have actual teeth, through enforcement that imposes consequences. The federal judiciary is done giving Trump the benefit of the doubt. 225 judges have said so. in over 700 cases, with increasingly explicit language, with faster orders, with stronger remedies. They're not being polite about it anymore. They're using contempt findings, discovery obligations, nationwide injunctions, final judgments. They're documenting lawlessness in written opinions that become permanent records. And they're showing that institutions can constrain authoritarianism when they stop treating deliberate defiance as good faith disagreement. The gloves are off. The deference is gone. The restraint has evaporated. And what's left is the federal judiciary using the full power the Constitution gives them to enforce the rule of law against an administration that thinks it's above it. This is what institutional resistance looks like. Not perfect, not complete, but real. And it's happening right now.
Thanks for spending a few minutes digging into this with me. If you want more grounded, progressive commentary without the outrage bait, subscribe and stick around. Every time you watch, share, and engage, it helps build a community that believes democracy is worth understanding and defending. I'll see you in the next video.